hear ye. The Honorable Chief Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Well, thank you. This is the second day of our two-day session in the month, and let me just say, as always, there are 30 minutes per side for full grants and 15 minutes per side for arguments on application. Furthermore, there is a 5-minute free fire period in full grants that may be waived, and a 2-minute free fire period in arguments on application that may also be waived. Your arguments, I believe, would be optimized if you recognize first that the justices are familiar with the basic facts in your case, and second, that the court is committed not only to resolving your case in a manner faithful to the law, but similar cases arising throughout our state for many years to come. I call the first case Department of Health and Human Services versus Rasmer.
Good afternoon, Aaron Lindstrom. On behalf of the Department of Health and Human Services, I'm joined at the council table by Assistant Attorneys General Gerald Brown and Brian McLaughlin. I would like to reserve some time, whatever's left, hopefully about 5 minutes when I'm done speaking. Mr. Chief Justice, and may it please the court. The long-term care Medicaid benefits at issue in this case are part of a welfare program that's designed to provide medical assistance to the elderly who are truly needy. So people, to qualify, must have less than $2,000 in assets, not counting their home. And the federal government and the state government have passed rules to try to preserve that money so that it can go to those who would benefit from it, so that it goes to those who don't have assets. And that's why they established a state recovery program, so that money that goes to those with assets can be recovered and put aside for those that need it. So that part of the plan was clear in 2007, September 30th, 2007, and this is the dispositive point on the due process arguments, that as of September 30th, 2007, it was clear under both state and federal law that if you received a bundle of Medicaid long-term care benefits from the state and the federal government, they had a string attached to it, which is that it would be subject to a state recovery. That's clear under both state and federal law, and it also was clear that it covered long-term care assistance. That's what's in the state statute. The federal statute says any medical assistance. It specifically covers nursing home care, home and community services. So it was clear at the outset, at September 30th, 2007, that the worst case scenario that could happen is that this money could be taken, if recovered by the state, if you accepted it, and then you had assets. So that shows that the very right that was relied upon by the Court of Appeals was actually vindicated in this case. When the first person in this case applied for benefits in 2008, all of this information was available, so they had the information to choose. Am I going to accept these long-term care benefits, which have the string attached, or am I going to not do that and instead attempt to preserve my estate? So that resolves the due process questions in this case. As to the statutory notice provision in G7 is the one that's actually a notice provision. G3E is only about what had to be submitted to the federal government. But G7 is specifically about the provisions of the plan. And so this is a requirement for notice after the plan had been approved. So that notice is a post-implementation notice, which has actually been provided in this case. Everybody in this case signed, and it's in the joint appendixes, one of these post-implementation program acknowledgement forms where they acknowledge that. So the statutory notice requirement has already also been met. I'd be happy to waive any free fire time that I have remaining. As to the judicial review component of the case, this is something that's it's a cost-effectiveness decision. That's a policy question that the legislature entrusted to the department and provided for a review by political.
Council, good afternoon. I figure I'll take the liberty of jumping in first. My question is, looking at the definition of the word eligibility, when I become 18, I'm eligible to vote, am I not?
Yes, Your Honor.
But once I become eligible to vote, can I just show up at the precinct and then vote?
I think you'd have to register, I believe.
Right. So how does that apply to your argument?
Well, I take that to be a statutory question
Yes.
about what the meaning of G7 is, which refers to eligibility. And the language of G7 says that the department is supposed to provide written information to individuals seeking eligibility for the long-term care services describing, and this is, I think, the key language, the provisions of the Michigan Medicaid State Recovery Program. So the Michigan Medicaid State Recovery Program is something that was submitted to the federal government in 2010, was finally approved. So that's what they had to provide notice about. And so the only way you can read that sentence to make sense is that you don't give that notice until the program has been approved. Otherwise, you're putting out bad information, and that wouldn't be the point of the statute. It wouldn't have been beneficial to anyone. So I think on the statutory notice question, I think G7 is fairly straightforward. I think the due process question, as I said, it's well established by the Supreme Court and this court that statutes that set out what the property right is, which is the Texaco case, and it's also this case, the federal statutes establish what the entitlement interest is, the expectation in this case is, and people have noticed that by virtue of that being on the books.
So if the decedent or his or her representative is provided with the information at annual redetermination, as was the case here in this case, and the decedent had decided, oh, I don't know, that sort of changes these benefits in a way that matters to me. I don't think I want them anymore. I want to, manage my estate differently. Would it be your view that you would be entitled to seek the payments that had been made up until that notice was provided in the redetermination?
The department has taken the position that it doesn't do that and has never done that.
So why then does the redetermination? I mean, why does why are you entitled to them just because they decided to keep going with them going forward?
Well, I think the department took a position that is exercising some prosecutorial discretion, so to speak, to not go after these ones and instead go after other ones. But they had, so if this is a question about due process,
Nope.
It's a question about the statute. So if it's a question about statute.
I'm just trying to figure out if the notice means, you have to be given notice, and I think when you sign up for your benefits each year, that has to be notice, right? If you're saying, okay, I understand that now this is the way this works, it's no longer a benefit as it used to be, it's more of a loan or however you want to think about it, and I still want it. That does seem like notice. I'm just not sure how it covers the period that came before you got that notice. And so
Right.
If your view is, if the claimant says, no, I no longer want the benefits, now that you've told me what it's going to mean, and your view is that means I can't claw back the ones that were provided before that date, how do you get to claw them back just because they said, okay, I understand that this is what this means now going forward?
I didn't say the department couldn't claw back. I said the department has decided not to. They're
Oh, okay. Your view
focusing
is
their
just-
benefits.
As just a matter of policy, they're not going to go after the ones, but
Right.
but they could have. Why could they have?
So I think the reason they could is because this notice provision doesn't bar any type of recovery. I mean, it's clear under the statute that when the legislature wants to say you may not seek to recover assets, it knows how to do that. And it's particularly clear in this context. We're talking about G7. G6 says the Department of Community Health shall not recover assets. And that's talking about certain homes where the surviving spouse or disabled or blind child or things like that. So in just reading the statute, the legislature knew how to impose a you may not recover assets stop sign. It did it in G6. It did not do it in G7. And this court is bound to follow the remedies that are given. This is an entirely statutory created right. It exists only because of the Medicaid statute and the state statutes. And the legislature did not give a remedy for if there's no written notice here.
Council, between 2012 and 2010, how many people are we talking about?
I don't know a number for that time period. I know that the recovery process for the state brings in currently about $5 million a year in 2016, for example. So it's covering a substantial number of people.
But at the end of the day, you're really talking about, and again, we're looking at it statutorily and policy-based, we're talking about a cost of about, so ultimately, you're looking at about $5 million of proceeds that would come from this?
I was only saying the $5 million is how much the department collects in 2016, for example. I don't know the answer to the specific group of people that you were talking about between 2010 and 2012. The estates in this case range from $125,000 in benefits they received up to $179,000. One of the estates had a $200,000 home. So the department, in its policy-making role, decided it was worth pursuing these assets.
Why? That's what I'm trying to get. I'm just trying to understand from a policy perspective. Basically, we're talking about, I think this case in a lot of ways comes down to the interpretation of a 2-year period. And that's what I'm trying to understand is why is this so important that, you're marshaling such resources on this between this 2010-2012 period against, in many situations, indigent folks with relatively small estates?
Well, I think the policy decision about who's indigent was made by the legislative branches when they said $2,000 is the cutoff for applying
right,
in the houses.
But you could have determined that we're just going to focus from 2012 on. I understand that you said that you could go back to 2007,
right,
but that you chose to go to 2010. So there was ultimately determination that was made to say, look, even though your argument being, even though we could go to 2007, we're not, even though we can, but we are going to go to 2010 rather than just 2012. 2012, I think it's relatively straightforward. 2010 is a different story. What I'm trying to understand is, so why? Why are we focusing on 2010? And what was the determination as it pertains to the significance of bringing the resources that you've brought over a 2-year time period against the type of people and the estates that are going to be affected?
Well, one of the overarching decisions is we're trying to comply with the law. We've been mandated since 1993
by the federal government. But there's a discretion, though. You could comply with the law by simply saying that we're going to focus on 2012 forward, but you're making a determination to go to 2010. As we talked about, you could go to 2007, but you're not, or you can make those arguments. What I'm trying to understand is, why are you just not satisfied with saying, 2012, we'd still be in compliance? Why is this such a significant issue that you are going after those 2 years?
It's the whether or not we'd still be in compliance question. When we were submitting the state plan back in the 2010 time period, the federal government's position that we had to start collecting immediately, that there would be no, we can't wait till May 11th, for example. So we're being pressured by the federal government that we need to start collecting this money. And the overarching concern to help the needy in this case is that we have to satisfy the federal government or we're going to lose this money. I mean, Michigan was the 50th state out of all 50 to actually follow through complying with federal law by establishing an estate recovery program.
But you don't know the exact, or you don't really have an estimate for us as to what the amount of money would be.
I don't, because
or the number of people that we're talking about.
I don't, because my focus has been on the statutory language, and the statute does not impose the bar. It's the legislature that gets to decide that we can't recover if for this pre-implementation period or post-implementation period, and the statute doesn't say we're not supposed to do it.
Counsel,
Yes,
is it at all implicit in your argument that any of the significant statutory developments that occurred here communicated notice that's relevant at all to this case? I'm thinking in particular of the enactment of the Budget Reconciliation Act all the way back in 1993, the enactment of MERP, the date on which MERP explicitly became effective, or the date on which the federal government approved MERP for purposes of the federal statute. Again, is it implicit or relevant at all that some form of notice was constructively or otherwise provided by those enactments?
Absolutely, Mr. Chief Justice. That's the first part of our due process argument, that notice has been provided by these statutes, and that, as I said at the outset, this provides what the scope of the right is. Anybody that accepted it after 2007 realized that this was something they were going to be subject to. And I think the fairness questions go to the due process argument, so that's directly on point. The statutory analysis wouldn't look at the fairness.
Well, how do those forms of notice differ in any way from the kind of notice that began in, I think, 2012 and 13, in which such notice was provided in the annual requalification enrollment forms? That was obviously more individualized notice, right?
It's more individualized. The actual content of the notice, I don't think is that different. If you look at the paragraph 12 of the acknowledgement form, it says, I acknowledge that my estate will be subject to estate recovery. I mean, it has that they have a legal right to proceed against my estate. And I think that information was already completely communicated by both the federal and the state statute by 2007. So again, as I said at the outset, the worst case scenario that they're going to come back and they're going to collect on this money was already part of the due process. And I think it's also telling in this case, for example, that everybody did sign the agreement and did stay with the program, and they did not take any different steps, for example, doing a ladybird deed as discussed in the briefings, to change that.
But that agreement was signed as a retroactive agreement, correct? It wasn't assigned, it was assigned retroactively. You were agreeing when you signed that agreement that they could take this from you going back. It wasn't that you signed this agreement in order to get the proceeds going forward.
It applied to going forward as well.
Forward
It
and
applied
back,
to both.
but there wasn't a situation where before that date where you were given proper notice that you were agreeing to this going forward exclusively.
And I guess I would say that they didn't receive individual notice before that date, but they did receive the notice that was on the statutes. And as the Supreme Court said, when you're doing a due process analysis, it's a fundamental premise of our democratic system that people understand and are held to know what the law is. And here again, I think that's especially applicable and fair in this context where we're talking about a statutorily created benefit in the first instance. If you're able to find out.
Fair?
Excuse me?
Did you say it's fair?
I used the word fairness because I'm talking about a due process argument, and there is a substantive due process argument in this case. I agree that procedural due process doesn't focus on fairness.
Okay, I was just
He's about to leave the bench because he heard the word fair.
No, but fair gets you a fair different outcome than law, though.
Well, I'm relying on the Supreme Court's interpretation of due process, so if I meant fairness in a way, I'll retract that. What my point is that the process that we have in our system of government was met here, which was that there was a statute that gave you
Let me
notice.
ask a question, a more serious question. Do you concede that Section 7 is a notice provision?
You're talking about G7 to make sure I'm
Yes,
making that?
G7, yeah.
It does say that the department shall provide written information.
So that.
Yes,
so
I think that is a notice requirement.
I'm just trying to understand it. If the statute says shall provide, why do you get to do something that is, that predates that required notice? Why do you get to attach assets that antedate the mandatory notice?
The reason you get to do it is because 112K says that the program, the estate recovery program, applies to recipients who began receiving services after the effective date, which is September 30, 2007. So there's notice in the statute.
Understood. Anytime the statutes say you're subject to them, that's fine, except there's another statute that says the state has to give notice. And you say this is a notice provision. I'm heading with you with G7. And it says that not DHS may, it doesn't say may, it says shall.
That's correct.
Okay. Shall provide written information, and then something else that seems rather critical, to individuals. So we're not talking about the generic notice statute, the enactment of the statute gives to everybody who might participate. This is notice that is required to be given to individuals who are seeking Medicaid eligibility. Now,
I agree.
Now I'm trying to figure out why the government is therefore free to seize assets before that mandatory notice is given.
Because if you read the rest of the provision, it's talking about information individuals seeking Medicaid eligibility for long-term care services. Now, here's what the written information that we're required to provide is. It's information describing the provisions of the Michigan Medicaid Estate Recovery Program. So the Michigan Medicaid Estate Recovery Program was not sent to the federal government. It wasn't in place. The program is how you go about collecting it, and you can see that from the statute itself. It's not kind of what the the obligation is. So what 112K does is it tells you what the loan obligation is and what G7.
I'm trying to figure out how I know that at the time I'm given this notice as a person seeking eligibility for long-term care, I understand that services I got before I signed this are at risk. How do I know that?
Well, that's on the form. I mean, if you're
The form
looking,
says that?
it says, and I guess I would point you to
Let's see if I've got the form.
203A in, I think this is our appendix, under state recovery. It says the state recovery applies only to recipients who received Medicaid services after the implementation of the program. So it's saying from the 2010 date forward, that's what it's going to apply to.
I don't think I understand that. To put me on notice that
It says to individuals seeking Medicaid eligibility. So you're sending me this. I'm re-upping. It's my time of year where I re-up,
Yeah.
and you send me this. And now for the first time, I see this instruction that says, "Hey, this has changed, and now if you agree to get your benefits, we're gonna be able to
claw the earlier.
claw them back."
Where does
but
that?
where does it say we're also going to claw back the ones that we
Already
didn't
give
give
you.
you notice to before now?
I
Where is that notice?
I think the notice is in 112K, because 112K says, here's what your loan obligation is. What 7 here is doing, it's describing the provisions of the collection program. And I'd like to explain why I'm describing this as the collection program. If you go back to what G2 says, when it says the department shall establish a state recovery program, what the program does is it, A, tracks assets. That's under the statute. B, it establishes actions necessary to collect the amounts. So the program is about how the state is going to go collect the money. It's not about what the obligation is. So the notice you're going to be getting is about how the state is going to be doing it. And if you go back to 112K, that says the obligation covers recipients' funds received after September 30th, 2007.
Does every state have a different program, and was it the idea that every state would have to submit their own way that they were going to collect this money?
Yes, every state has to go through this process. I can't say that no 2 states have the same program, but every state has to submit it, get federal approval, and there's lots of different
And we
programs
were
out
very
there.
late to the table, right?
Say that again. Yes, we were the
Michigan was very
50th
late.
state. That's correct.
Last one. We waited 17 years.
That's correct.
Or
And
something
we
like
did it at the risk of losing all the funding for all the Medicaid recipients in the state.
And I'm trying to understand the statutory notice too, because you have a federal law that says you have to do this, and then we finally showed up with our state law all these years later that said, we're in the game now, we're going to try to do this. But then it had to go through more regulatory hurdles where we had to submit it and have it approved. Should I be concerned that all of this confusion between federal law and state law and administrative law would make it difficult for someone to understand by just looking at, I'm not sure which one of those statutes you could look at, that they may someday be subject to recovery? Because they know, one thing you know if you live in Michigan and you pay attention to this, is you know Michigan has been blowing off the federal government for maybe 15 years. So you're kind of skating pretty free, right? During that period, you know the opposite. You know you're not subject to recovery, right?
But that extra emphasis and knowledge about Michigan being an outlier is something that would also put you on additional notice. You know, I think the statute...
Well, that Michigan may someday do something.
Yeah,
And
someday
Michigan-
this might change for you. You
and
know, someday this might change for you. But
And
so
it
far,
changed
so
for you
good.
on September 30th, 2007, because at that point, the statute is clear that if you receive funds after that date, then you're going to have to repay them back. And again, what G7 is about is it's about how the program is going to work, what the state recovery program is going to be. That's why G2 talks about establishing a program that tracks assets and actions necessary to collect amounts. It's the collection
I
program.
don't see G7 being as you describe it. It says I got to get, if I'm seeking eligibility, I've got to get written information that tells me what the provisions of the recovery program are, including but not limited to a statement that some or all of my estate may be recovered. Now, that to me says, okay, if I sign this, going forward, some of my estate's going to be liable to be recovered by the state. What it doesn't tell me is that if I've been receiving benefits beforehand, those also may be recovered. So I'm looking for you to help me understand where if the written notice itself tells me that my prior payments are also subject to be charged against my estate. Is there something concrete that you've given to the recipients that would at least tell them that?
I pointed to earlier to the language of the notice that's in the acknowledgement form.
Okay. I don't have mine in front of me right now.
I apologize. That's at 203 of the appendix. The estate recovery, it applies to certain Medicaid recipients who receive Medicaid services after the implementation of the program. It also talks about the services. I guess the key part of that
after
notice.
implementation is now, right? 2017, I'm signing up. What I'm looking for is something in the notice provisions given to me about the written information that allows me to know the benefits I got last year in 2016 are going to be recoverable just as the ones I'm going to get in 17.
And all the way back to 210 instead of 27.
Right.
How do I know, this notice that I'm understanding right now means they can go back to the benefits that they took from 2010 rather than 2007 or some other date?
So my first tier answer is still that 112K provides that notice. The written notice that's required about the state recovery program is, again, you can't.
Yeah, but it doesn't tell me in a way that I guess maybe I'm asking, maybe it isn't relevant to from your legal analysis, but I'm still trying to figure out if I'm advised, not only will my assets going forward be clawed back, but also any that I received before. And other than the generic statement that the statute gives the state to create a program
Right.
for recovery,
Right.
you're saying no.
No, I'm saying, your question is, did you have notice that go back to 2010? Right, that's the implementation date.
Okay.
And this notice here says yes. It says received Medicaid benefits after the implementation date of the program. So
Let me just make sure I understand. That's as specific a notice as exists in this regime, that when signing up in January 17, if I've been a recipient beforehand, that my assets before 17 are at risk. There is no more specific notice to me that, oh, by the way, not just 17, but the assets the benefits that you got before 17 can also be clawed back from your estate. I just want to make sure that I've given you an opportunity
Right.
to tell me, nope, that's a specific.
This is the most specific language in the form that's given as an individualized manner, but I do still continue to argue that the statute as a whole provides, first of all, there's a difference between the notice that's being talked about in G7. It's about the provisions of the Medicaid State Recovery Program, so it couldn't be given sooner. But once it is given, that tells you how they're going to recover, and it's 112K that says the period for which they can recover. I'd like to try to reserve some rebuttal time, if I may.
Actually, I'm sorry, I just need to ask one question. Even if the department had an obligation to provide the kind of specific notice that the Chief Justice seems to want, what would be the remedy for failure to do that?
And
so there might be a duty, but usually we say that there has to be injury and some kind of provision for a remedy. So where would we find that here?
I agree. There is no remedy in the statute that's set out. And
What about
again, I'd
bail
like
bond?
to contrast.
I'd just like to know what you think about bail bond before I let you go.
Say that again. Which part?
So we have this case, right, in re forfeiture of bail bond that
Yes.
says when something is
Sure.
mandatory, it's a directive given to an officer, he can't act as if he complied with the mandate even if it doesn't exist. How do you think that maps onto this case?
I think a large part of the analysis in that case talks about the fact that if you didn't get that notice, you wouldn't be able to safeguard your rights. So if you didn't get the notice in that case, you wouldn't have been enabled the surety to go after the person to try to recover their money. They would have been directly affected. They wouldn't have had an effective opportunity.
Wasn't that notice given?
And my point would be that the property right here that's at issue is this right to notice. That notice has already been given by the statute. So the person back in 2007 had exactly the opportunity that's protected by 7, because they have the choice to
Their
make.
benefits
Below
were made
it was the statute. I thought your argument has always been when you recertify, you were given the written notice to comply with the statute. Is your argument now that the statute itself is good enough for the notice and the
I think
recertification is
It
irrelevant?
depends on which question you're focusing on. If you're focusing on the requirement of the Constitution to provide
Nope,
notice,
statute.
then
Where's
so
the
if you're
statute? We're just focused on the statute and the bail bond case.
right. So in the bail bond case, I think that ties in, because in that case there was a right that wasn't protected any other way. Here, I think you have to look at what the underlying property right is that's being protected.
Okay.
That's part of what the bail bond analysis was. Here, the underlying property that's being protected was this notice, this opportunity to choose. That's how the Court of Appeals defined it. It's to have this information. And my point, I think that part overlaps the due process argument, because that property right and having enough information so that you could make this informed decision has been granted. Remember, the Court of Appeals ruled on due process grounds. They didn't rule on statutory
But we don't
analysis
have to do what
grounds.
they did. We don't have to agree with them on due process. We can be focused on the statute. They might not have
Right.
gotten that part right.
But so if you're going to go that route, you'd have to find some right that's embodied in the statute that has a
Written
remedy for it.
information.
Pardon me?
Shall provide.
Written
And that
information.
goes back to the remedy. The general rule under statutory
A
interpretation.
statement that some of all of their estate may be recovered. What is the statement given to a beneficiary that some or all of their estate may be recovered, and during what periods?
Even if I were to concede that duty was not met, that the written notice duty was not met, there still is the second point, which was brought up by Justice Larson's question as well, that there's no remedy set out in the statute here. And the
then you
statute,
followed
it
it up with
immediately.
bail bond.
Bail bond
Bail bond
is a
says.
problem for you.
Is a problem, isn't it?
I don't think it's a problem, because here, the underlying right was still protected. Bail bond says you have to be able to protect the underlying right, which is this right to make a choice. In our case, it's the right to make a choice. Here, the right to make a choice has already been made, because you could still know enough information at any point in this timeline
Can
to
I ask a
know.
question about that enough information point, because that kind of follows on the question I asked you before, which is it, if it's the case that the federal government sort of, in the statute said you had to do this in 93, and we didn't do anything until 2007, and then we enact a statute in 2007 that says we have to put together a program, and every state's program is different, is it enough information for people to know that we're now going to put together a program that then has to be approved? Will that give them enough information to rearrange their affairs and protect their assets or do whatever that they're going to do? In other words, is the content of the notice that you're urging, should we be concerned that it would not be specific enough to allow people to protect their property rights?
I think I take that to be a due process question, and the due process point is, there is enough specific information to allow people to make that precise choice, because the statute notifies them that estate recovery is going to happen after the date. And if I receive benefits after September 2007, then that money is subject to estate recovery. And you're given the benefit, it has the string attached.
In other words, your argument is that the mere failure to enforce can't be sufficient to create an entitlement not to comply with the law or be subject to the law.
I agree.
So an
with that.
analogy might be, it's illegal under federal law to possess, sell, trade marijuana, but the states have said no, but that doesn't mean the federal government, and it's complicated, states have different regimes, but that does not, as far as I know, mean that the federal government can't arrest you for that crime. And
Right.
you couldn't
In fact-
assert lack of notice.
Right, you'd be bound by both sets of laws, even if one set of law let you off.
But I'm not sure how to apply that here. I concede that the state statute that says when we get this all stuff going, you're going to be at risk. But there's this G7 provision seems to be more exacting about what kind of information the state is obligated to give. And that's what's troubling me. I know you're at risk, but until I tell you specifically about the program we now are going to enforce, I'm not sure why that notice provision has been satisfied.
And part of the notice that's given is that it is going to apply after the implementation date.
Yep.
So that goes to that tells you that if you're on July 2nd.
I've got the notice now, I know my assets,
Right,
certainly going forward, are at risk.
right.
What I'm missing is why this is, what notice was given that I'm also signing off, I'm waiving
Right.
the benefits I've already gotten to date without notice.
Right.
They're also at risk.
So I think the best way I can explain this is that, and if I can just have 10 seconds to say this, the
I've asked you a question, I'm
112K,
interested in the
112K sets out like what the terms of the loan are, and what G7 does, it says, here's the repayment plan. We're going to give you notice about the repayment plan. We're not going to start collecting instantly. We may give you a 3-month time period before we start collecting on it. But the first part's what the terms are, and the terms are clear under the statute. And that's something that is provided in the notice. It says, I understand that upon my death, the Michigan Department of Community Health has the legal right to seek recovery from my estate for services paid by Medicaid.
Services. So that is actually some greater notice that for benefits paid is
Right.
not benefits paid from this day
It's a,
forward.
I should have started with that. Yes, Your Honor.
Possibly.
That would have been simpler.
Thank you, Mr. Lindstrom.
Thank you, Mr. Chief Justice.
May it please the Court, Gary Pisapanish on behalf of the estates of Olive Rasmer, Irene Gorney, William B. French, and Wilma Ketchum. As the appellant in the Olive Rasmer estate case, I would like to request 2 minutes of rebuttal. These consolidated appeals concern the Michigan Medicaid Estate Recovery Program.
Counsel, there's no more entitlement to rebuttal on the part of Mr. Lindstrom, so I don't think there'll be any opportunity for further time.
Chief Justice.
Thank you.
These consolidated appeals concern the Michigan Medicaid Estate Recovery Program and the efforts by the State of Michigan's Department of Health and Human Services to collect the costs of long-term care services provided to Medicaid recipients after their deaths. At an abstract level, these cases are about the relationship between the individual and the state in a liberal democracy. Specifically, these cases present paramount issues concerning the constitutional protection of individual property rights in the face of the department's overreaching claims seeking recovery from the individual's estates for Medicaid services provided to them while they were alive. This court poses 3 interrelated questions. In answer to the first question, the state statutory scheme does not allow the department to seek estate recovery without providing the Medicaid applicant at the time of enrollment in the Medicaid program for long-term care services with reasonably sufficient written notice of the provisions of the estate recovery program and what actions may be taken against the individual's estate after his or her death. Specifically, this court is asked to read the statutory provisions, MCL 400 112 G3E and MCL 400 112 G7 harmoniously to require such written notice describing the provisions of the estate recovery program at the time of enrollment in the Medicaid program. Second, pursuant to Mullane v. Central Hanover Trust Company and its progeny, the department's failure to provide timely and reasonably sufficient written notice of the provisions of the estate recovery program to a Medicaid applicant at the time of enrollment violates the individual's right to procedural due process under the 14th Amendment to the U.S. Constitution and Article 1, Section 17 of the 1963 Michigan Constitution. Mullane states that notice must be reasonably calculated under all the circumstances to apprise interested parties of the pendency of the state action. Further, as stated in Goldberg v. Kelly, adequate notice must be reasonably certain to actually inform the party, and in choosing the means, the state must take into account, quote, the capabilities and circumstances of the parties to whom the notice is addressed, unquote. In short, adequate notice is at the heart of due process. It represents fundamental fairness in the administrative process and provides critical safeguards to protect our frail, cognitively challenged elderly citizens, many of whom are suffering from chronic illness or disability against the arbitrary action by the state. Finally, the state's estate recovery collection efforts are not at its sole discretion, but are subject to judicial review, specifically in making cost-effectiveness determinations under MCL 400-112G4, the department must adopt a reasonable definition and methodology of cost effectiveness, which is subject to judicial review to ascertain whether it is authorized by law and whether its factual findings are supported by competent material and substantial evidence on the whole record. I'm here to answer questions, Your Honor.
Do you have I've been looking through the appendix. Do you have the actual application in front of you, available to you?
The application from whom?
For long-term social.
I don't have that right in front of me, Your Honor. No, I don't.
Do you know what it says?
Well, yes, I do.
Okay. Does it put an applicant on notice that when they sign this, that the benefits they've received can be charged against their state and recovered by the government?
Not just going forward, but the ones they've
At
received.
benefits received. Does it say that? That's what opposing counsel just read us. I'm looking through the
Your Honor, I'll have to say I have not seen any evidence of that.
Well, I'm asking something.
And I haven't seen
very
it
different.
in the application.
Just a moment, sir. Opposing counsel read a statement purportedly from an application I can't find in my materials that says that as a recipient, if I sign this, that the benefits received may be recoverable from my state. Is that an incorrect or correct statement of what the benefits statement says?
Well, yes, it does. I mean, when you sign off.
First, is that an
Yes.
accurate statement? Okay.
You say the acknowledgement section of that says that.
Okay. Now, my question then is, if I am told that the benefits received are recoverable from my estate, what's deficient about that notice? To tell me that not only the benefits I'm getting going forward, but the benefits I've received are within the ambit of what the government may take from my estate.
Well, the problem that we have here is clearly there's a timeliness issue, and there's also the specificity. I don't believe that the timeliness is satisfied because, as I argued in the briefs,
That's a different question.
Okay,
Just answer my question right now.
the second part, though, the second prong is the specificity. Does that bare statement provide enough information for an elderly citizen with family members and perhaps advised by counsel to understand that they can go back retroactively? And I
Benefits
say,
received is not the same thing as benefits from here on. Benefits received is not an ambiguous term. Social Security benefits received. If I've been receiving them before now, I understand, if I'm compos mentis, that all those benefits can be recovered from my estate. Isn't that right?
well, it does say that you could interpret it that way, that's for sure.
Well, how would you interpret it?
I think it's open-ended. It's not clear, because what benefits are you talking about? And you could ask for a greater specification.
Unemployment benefits?
No, we're talking about the timeliness. How far back does it go? Why does it go back? It can go back to 2007, could go 2010. In the case of Olive Rasmer, for example, she signed off on this in September of 2013. What
In
did
2013, she knew that she was signing a document that acknowledged that the Social Security benefits she received could be clawed back by the state from her estate, right? That's what the statement says.
I'm not going to go so far as to say she knew.
Okay.
You're presuming that that was sufficient information that was provided to somebody who was fairly elderly, in frail condition, and probably was not aware exactly of what this kind of statement meant.
The form is what you're saying.
Well, I think when you look at the question of notice, it has to be tied.
You're not asserting incompetency as a
No,
defense.
of course
All
not.
right.
Of course not.
Okay.
But I'm saying, I'm looking at the kind of notice that's given here and focusing on the acknowledgement form, and I look at that, and you have to scrutinize it And you say, is that enough? And what are we talking about here? What kind of a clawback are we talking about? And if I were someone like Rasmer or any of the others, Irene Gorney or William B. French or Wilma Ketchum, I would be deeply puzzled about what to do. I would seek counsel advice about it. It seems to me it's not clear enough, specific enough, and it doesn't meet the demands of due process. And further, but let's go back to the statutory issue, though. I don't even think it satisfies the statute at all, because the statute requires, as you pointed out before, G7, describing the provisions of the estate recovery program. Well, what kind of description, what level of description is required here? I think a high level of specificity is required to satisfy the demands of the statute as well as due process.
Okay.
And by the way, the other thing is that if those statutory demands or requirements are not met, these are independent requirements. This is independent of federal law. So if those statutory requirements are not met, then the state cannot engage in estate recovery collection efforts.
So
and I think the probate
I'd like
courts...
to ask you about that. Why is that true, that even if the statute says, and the statute does say, that the department must give a statement that some or all of their estate may be recovered, and let's assume that that requirement was not met in this case. But then the question is what to do about that. And I think I need you to help me build an argument about what we do about the state's failure to comply, assuming that the state has failed to comply. Why do you think that automatically means that the state can't attach the assets in the estate?
Well, I think there's a couple of different answers that could be given. Probate courts, if you look at some of those decisions and you scrutinize the reasoning of some of those judges, what they concluded, I believe, and then we're going through Gratiot County and probate court, the Clinton County probate court decisions, what they were concluding was you have to satisfy these statutory requirements, state of Michigan. And if you don't, these are laid out. This is an enabling statute. If you don't, then you cannot engage in estate recovery.
But I'm wondering why that's true. So it just can't be that every requirement in a federal program that requires some government officer to do something, if they don't do it, then the whole program falls apart. So, for example, if there had been a requirement here that said the Department of Health and Human Services shall hold a meeting with some other government official before implementing this program, and you find out 10 years later that the meeting never took place, you would not say the whole program is null and void. So there has to be some. Why do you conclude that the remedy for failure to comply with this particular statutory requirement is that they can't go after the estate?
Well, I'm looking at it from what the probate court judges said. I think they provided one answer to the question that you posed here. And I think what those probate judges were looking at was basically to say that these are preconditions. This is a condition precedent for the triggering of the estate recovery program. Keep in mind.
Why do I know that? That's my question. How do I know this is a condition precedent when other things might not be?
This is a Michigan Medicaid estate recovery program. It's not anybody else's. You have to satisfy these requirements. And if you don't, then we're not going to enforce this program in the state of Michigan. I think that's what the probate court judges were thinking. Now, that's the answer they gave. The answer that I tended to give, and I was being very uncertain about this because I don't think it's clear. First, I thought, well, you have the bail bonds, the bonds case, and I thought this court can provide the remedy. Of course, the statute doesn't necessarily have to provide it. Courts can do that. And courts do it. Whether the court will do it here, well, that's your decision to make.
Do you think we're compelled to do so by the bail bonds case?
I think the bail bonds case is persuasive. grounds for doing it here. That's why I brought it to your attention. However, here's the third possible answer to this question, is that, okay, fine, we don't have a statutory remedy. We say, okay, fine. We have a constitutional remedy here, and that pushes this case into the constitutional analysis. That's why I say the inquiry doesn't stop here. You have to go on to the due process issue, and you have to analyze that, because the Constitution does provide a remedy. That means to say that the state of Michigan, you cannot collect from the estates of Olive Rasmer or any of the other estates until you provide timely and reasonably sufficient notice under the 14th Amendment of the U.S. Constitution.
So if we're going to hinge it on a constitutional remedy, let's assume there's a constitutional violation. But then I would think there would need to be, I mean, this is a notice injury. Your claim is I didn't get sufficient notice. And so then I wonder, well, what difference would the notice have made? So if, for example, you were a criminal defendant and you weren't given certain notice, ordinarily we would say, well, but if it wouldn't have changed your behavior, then it doesn't matter. So I guess then I need to know, like, how was your client harmed? What difference would I mean, you have multiple clients. Help me with the harm part.
I think there's various ways to look at this, and again, it goes to the question of what's at stake here. And I take issue with the state of Michigan's claim that this is a statutorily created right that's at stake.
Right,
it
so
is not.
Even if you want to call it
It's a property
constitutional
right.
but
It's a property right. It's a property
right, but the right that, as you framed it, I think, is the right to manage your estate during your lifetime, make decisions about health care in order to affect your estate planning. But if it's a knowledge, if your injury is you didn't get the information necessary to make the decision, then either I would think you would have to show that you would have made some different decision, or the state would have to show that you wouldn't have made some different decision. But like, if the knowledge is the thing of value, if you weren't harmed by the lack of the knowledge, it's hard to see how the Constitution provides you a remedy.
Well, I think the presumption by the state is that you're not harmed, but I think that's false. I think each of these individuals has a right to make a determination based on the proper information about what they want to do with their assets. It's not as though the state controls their assets.
Oh, I completely agree.
And some of these estates, well, some of these individuals, the Medicaid recipients, like Olive Rasmer, take her for example. I think it's a perfect example. When she signed off, or had a representative sign off in September of 2013, she didn't have to do that. She needed more information about what to do. She needed a more savvy representative, perhaps, who would have spotted, as Chief Justice Young just pointed out, well, doesn't it say that you're opening yourself up to a state recovery? Well, I'm not sure that somebody in Olive Rasmer's condition would have known that. And I don't think the knowledge, the information that was provided was sufficient. But what if she had just walked? What if she had a savvy attorney who said, don't sign it, Olive, just stay in that nursing home? What are they going to do, kick you out? Of course not. She would have stayed there, and then she would have died 4 months later. The state would have had no grounds for recovery at all. And so you're asking, well, would it have made a difference? Of course it would have made a difference. Each of these Medicaid recipients had an individual right to have proper information, to make a fully informed decision about what to do with their assets. Some of them might have stayed with their family members.
Are you saying that had she stayed in the nursing home couldn't recover against her estate?
Well, perhaps. We're talking about $30,000 as opposed to $170,000.
No one has an entitlement to these benefits. This is in essence a loan program, advancing money against an estate. So when you characterize this as a property right, yes, you have a right to your own estate, but you don't have a right to the benefits. And this program says if you take these benefits, eventually your estate's going to pay them back if it's able. Right?
But if you are fully informed and you realize it's not a very good deal, you might not decide to do that. You might not sign off on these Medicaid redetermination application forms. You might just walk. And that is a free choice for all of these individuals and for everybody out there. This is why I say it's a fundamental question of the relationship between the individual and the state. Individuals have a choice, and they can make it. They might decide the best game in town is the state of Michigan's Medicaid program. Well, so be it. And if that's the case, then they're stuck with it. But they didn't have that choice here. And in fact, I'm going even further. None of the people in the state of Michigan at the present time have that choice because the state of Michigan has not provided a proper notice statement at the time of enrollment that reasonably describes the provisions of the state recovery and what actions could be taken against their estate after their deaths. And that is really the issue here. The state of Michigan has to reform their notice statement. This bare notice statement and the acknowledgement form is inadequate for due process purposes, and I think also for statutory purposes too, but that's up to this court to decide. Any
Are you
further
done?
questions?
Okay, thank you, sir.
I
Thank
have
you.
one question for Mr. Lindstrom.
Okay.
Is the application that you read from in the record? I couldn't find it in any exhibit in the
Looking at
appendix.
page 203A, and it's in there 4 times. This form is in there.
203A what?
203A in the appendix in the department's
Departments.
brief.
Exhibit.
So it'd be the Gorney case.
And is that paragraph 12, estate recovery?
Yes, ma'am.
Because you read something about benefits received, and I see paragraph 12 saying, I understand that upon my death, the Michigan Department of Community Health has the legal right to seek recovery from my estate for services paid by Medicaid.
The services paid language is in that first sentence. Benefits received is in the later sentence. I think in the first sentence, services paid by Medicaid is benefits paid. I mean, that's the same thing.
Where does it, I'm sorry,
It'd be the received Medicaid services would be the 4th line down. So estate recovery only applies to certain Medicaid recipients who received Medicaid services after the implementation date of the program.
oh, I see.
So that's where
Oh,
it says received,
I see.
and it says services paid in the first
Services
sentence.
paid. Okay. Thank you. I'm done.
Thank you.
Counsel, if you'd like, I'll give you 30 seconds to respond if you have anything to respond to. There are quirks in this case. You're part appellant, part appellee.
Well, I'd like to just summarize by saying I think this court can write 2 different opinions in this case. It can either resolve this on state statutory grounds alone. I'm not sure if that's going to be sufficient, though. If I were writing this opinion, I would push it into the due process analysis, because I think the due process analysis, Moulin and progeny, provide the kind of strength and bolstering that you need in the specificity of these notice requirements. And I'm thinking of the Mennonite case in particular, because what they say is, the U.S. Supreme Court said that even if you're the mortgagee and you have the ability to find out what your obligations are, the state still has a constitutional obligation to provide proper notice to you. And it has to take into account the kind of frailties that we're talking about with these individuals. You can't exclude the idea here that these are just bare individuals. No, these are people who are frail, who are on their last legs, who are making their final life decisions. Thank you.
Thank you, counsel. Thank you very much.